Welcome to today's program titled Developing and Maintaining a Multi-State Employee Handbook, Best Practices and Updates for 2024. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Mesa. Chelsea, please go ahead.
Thank you so much. And thank you all so much for being with us today. As she mentioned, I'm Chelsea Mesa. I'm a partner in our downtown Los Angeles office, and I also run our national handbook and policy team. And I'm absolutely thrilled to be joined today by three of my very favorite colleagues and team members, Jean Wilson from Boston, Charlotte from Sacramento, and Renata from Atlanta. And they're going to be with me guiding you through the world of handbooks. So welcome to handbook season. I know it's a little bit of a spooky season, but it is my favorite season. And so we're always really thrilled to be able to spend some time with y'all. We've got a lot to cover, so we're going to move really, really quickly because there is just a lot that's occurred in the last year. One of the reasons why handbook season is particularly spooky this year. So we're going to dive in just a couple of minutes to the federal and state developments that impact our handbooks and policies. And just so y'all understand, we're not trying to do a completely all-inclusive list of absolutely everything that's changed that needs to be updated for 2024, but we're going to give you some really big ticket items that are important to note for specifically with respect to what you need to do in your handbook. And we're going to spend most of our time today on that section 2 as we go. Section 3 will give a little bit on the importance of having an employee handbook and corresponding addenda. And then we'll do a little subtle plug for the work we've been doing and how awesome a job that I know this team can do for all of y'all if you need your handbook worked on. And then we'll end today with some trends, what we're expecting to see through 2024 and 2025. And so it is a very exciting time. So we know that we've seen a lot, but we expect a lot to happen. But why don't we go ahead and dive right into our first section, which is federal and state developments. And I'm actually going to start with the federal developments right out of the gate. I usually wait in these webinars to talk about the NLRA and the NLRB and federal developments until kind of way late in the session. But we have seen some pretty significant developments in this space, and so we thought it would be fun just to kick it right off. I guess my definition of fun and yours might be a little different. But we did a whole webinar on Stericycle last week, and hopefully many of you joined. We do have that available online, so I'm not going to get into an enormous amount of detail, but just by way of background, as all of y'all know, under the NLRA, an employer is prohibited from having policies that are going to interfere with an employee's right to engage in unionizing or other concerted activities. And we know that applies to both union and non-union employees, and that the state of the board changes depending who the administration is. I think we were looking at a very a very employee-friendly board under the Obama administration, and we sort of expected the Biden board to look relatively similarly, and they really did, but took it a step further with Stericycle on the next slide. I'll go through some of the high points of that really quickly. Basically, the NLRB held that a neutral work rule is presumptively unlawful if an employee who's subject to the rule and, quote, economically dependent on his employer and who, quote, contemplates engaging in protected concerted activity could interpret the rule to have a, quote, coercive meaning, then we've got a problem. So it really is something that takes it a step further than we were expecting and makes it a little bit difficult for employers to figure out how to draft these policies that on their face are very neutral and aren't designed to prevent somebody from stopping their concerted activity or not engaging in unions. But it really is going to be viewed whether the rule itself has a reasonable tendency to chill employees' exercise of their Section 7 rights. And whether that tendency exists is going to be viewed from the perspective of a reasonable employee, not a lawyer. And that means somebody who is subject to the rules, somebody who's economically dependent on the employer and is actually contemplating and engaging in protected activity. So it really does make a lot of assumptions that hadn't been made before. And so we want to be really mindful that that puts us in a place where we really should be reviewing all of our policies. On the next slide, we run through the ones we think are most likely subject to scrutiny and challenge, things around confidentiality, electronic communications, our complaint policies, the way in which employees raise complaints. But these are the types of things that we want you to be paying special attention to. And really importantly, on the next slide, taking a hard look and asking yourself these questions as you go. And we can obviously help y'all navigate through this as well. Number one, what are you trying to protect, and is it really necessary to do so? Do we have the ability to justify this policy or rule? Do we have that justification somewhere in writing? What about things like illustrative examples? Can we include examples of what we actually mean and what we don't mean in the policy? And that will be, we think, really, really useful. And also considering those savings clauses and disclaimer language. We know the NLRB has said that a disclaimer in and of itself is not going to be sufficient, but we certainly don't view it as something that's going to hurt as long as it's not the only thing you've got. So going through this exercise, making sure you feel comfortable with the policies you're putting forth, why they're there, explaining what they do and what they don't do, and having that savings clause, that disclaimer, maybe even several times throughout your handbook in the places where we feel like it's most likely to be misconstrued. Having a disclaimer more than once, having it more than twice, having it more than 5 times certainly doesn't hurt you. And so it's something that we're certainly recommending as part of our review now that the Stericycle case is with us. So something to keep in mind from a federal level, that everybody needs to take a look at pretty much every policy in their handbook as they're doing their 2024 update to see if there is any room for tailoring things back, scaling things down under the new lens of this particular case. I'm going to kick it over to Jean now to talk a little bit more about some of our federal developments in the pregnancy space.
Thanks, Chelsea. I appreciate that. So really the other federal development that we saw this year is the passage of the Pregnant Workers Fairness Act, and that went into effect June 27th. So it's been around. A lot of people are familiar with the concepts of this law because it is, we've seen a lot of state laws in this area as well. And essentially what it does is says that employers have to provide a reasonable accommodation to pregnant employees. It essentially grafts kind of the ADA interactive process onto, pregnant individuals. So you generally use the same process. The one thing that may be a little different is that it looks like they're not going to require that a person be able to perform the essential functions of their job. So there will be, in certain circumstances, essential functions that if somebody can only not do them temporarily, that you will have to excuse. And temporarily, at least the EEOC's interpretation of that is the full course, 40 weeks of a woman's pregnancy. And then once a person returns, 40 weeks from the date they returned. So it's something to keep an eye on. And then the other federal development was the PUMP Act. And again, this is something most of you are familiar with, providing both breaks and a space for women who are need to pump at work to express breast milk. And so this one from a federal level is pretty in the middle in terms of what it requires. You have to provide the accommodations for up to a year. The breaks don't have to be paid. What you will want to pay attention to, and kind of going into the next part of the presentation, is that there are some states that have these laws where they differ and have different, more stringent requirements. So we can go now into, that leaves federal, and we're going to go right into New England and some of the changes in the Northeast. I'm sitting in Boston today. It feels more like I'm sitting down south because it's almost 70 degrees. But and so the first state we're going to look at is New Hampshire. And as I was just talking, New Hampshire has now, effective July 1, 2025, passed its own lactation accommodation law. And one of the things to note about New Hampshire is that it does actually require employers to maintain a policy. So that's why we wanted to highlight it here, because it will need to it will need to either be in your handbook or in your list of policies. And, you know, one of the, you know, you can kind of see where some of these differences come in. One of the things in the New Hampshire law is that, you know, it says you have to give reasonable breaks, and then it goes on to define that as 30 minutes for every 3 hours of work. And so that's one of the areas where we sometimes see more or less clarity and difference in the state laws. One of the other things you'll want to look at is how many years do you have to provide this? There's a couple states where it's 3 years or there is no time limit versus only providing the accommodation for 1 year. So that's it for New Hampshire. And then our next state is, I believe, Massachusetts. Where are we going? So the next state is Connecticut. Sorry about that. And so we are, the only change for Connecticut, I believe, this year is sick time. They have not changed their actual sick time law in terms of there had been a bill in front of the legislature to expand sick time in Connecticut to almost every employee, but that didn't pass. But what did pass was the existing law, which applies only to service workers. Now those employees can take the day off for a mental health wellness day. And then the safe time has been extended to time off if an employee's child is a victim of family violence or sexual assault. And you can see here that the mental health day definition is quite broad and is essentially, you know, any time an employee needs to take off to attend to their emotional and psychological well-being. And, you know, we probably will see more of this across the country as well. Next, I think we have Massachusetts. And so the big change in Massachusetts seems like a little change, but it has a big impact. So as of November 1st, so next week, the Mass Paid Family and Medical Leave has been amended. So unlike every other paid family and medical leave law in the country, if you were using the public option, meaning going to the state for your employees to get benefits, you could not allow your employees to top up their state benefit with accrued paid leave, sick time, vacation, personal time, floating holidays. They've now changed the law so that employees now using the public option can do that. What the Department is saying, of Family Medical Leave is saying, is that you cannot require people to use this time, but you have to allow them to use the time. So very permissive in terms of what an employee can do. And so people really do need to look at their policies because most policies on the public plan don't allow for this. And then I just wanted to mention quickly holidays because I'm still getting a lot of questions on this. As of January 1st of this year, 2023, Massachusetts did away with their premium pay for holiday work, so that's something you do not have to worry about anymore. Next slide is Maine. So Maine just changed their vacation law, so now requires payout, so you'll want to pay attention to that. Also, Maine has passed a paid family and medical leave. I just wanted to raise that. Benefits won't be available to May 1st, 2026. Contributions will begin January 1st, 2025. So more to come on that, but just to keep it on your radar. And then Vermont is, I think, our last one. And just wanted to let you know that Vermont has a paid family and medical leave, but it's voluntary. And as of July 2024, private employers can start offering benefits. You know, people can elect into it. So that is another one. You don't have to do anything about it, but you should at least be aware of it if you have employees in Vermont. And then just quickly on harassment, Vermont, and we've seen a couple other states do this as well, has changed their harassment law so that employees no longer need to demonstrate that conduct is severe or pervasive for it to be considered unlawful. So just want to keep that in mind, and you want to look at your harassment and discrimination policies and make sure that the standard doesn't overstate, you know, that everything has to be severe or pervasive, because that's no longer the case in Vermont. And now I believe I'm going to hand it over to Renata.
Thank you, Jean. So I will be talking about New York, starting with New York State on the next slide. The state adopted a revised model sexual harassment policy this past April. So employers are going to want to take a close look at their New York non-discrimination and anti-harassment policies to make sure that they are compliant. There are a number of elements in the New York policy that we don't always see in nationwide policies. For example, there's some specific information regarding gender diversity considerations. There's some detailed information about external reporting procedures and that sort of thing. So this is going to be something that would be customized for New York. There's also a new lactation accommodation law in New York, which requires employers to provide lactation breaks for up to 3 years following the birth of a child. And there are some differences between the New York law and the new federal PUMP Act that we addressed earlier in the presentation today. So again, it's going to be important to review these New York specific policies for any employers that have New York employees in New York State. On the next slide, we'll talk about New York City for just a minute. The city recently released new rules related to its earned days and sick time law. These rules went into effect on October 15th, and most notably, they do include some specific information that is required to be included in an employer's written policy, but they also provide some clarification on a number of other topics, such as accrual and remote workers, among other things. The city also added height and weight discrimination as protected characteristics. That'll go into effect next month. And I will now pass the mic back over to Chelsea to tell us what has been going on in California.
Yes, indeed. Thanks so much. In California, we title it as our most employee-friendly state. I know there are a couple of states that are starting to rival it, so it's not as easy to call it that. And we've had some developments this year, a couple of pretty significant developments. Starting in the bereavement leave space, I know y'all remember from last year that we implemented a brand new bereavement leave policy that provides 5 days per death, essentially, for employees to take, not required to be a paid benefit, but that was last year. This year, what they've done is they've amended that law to include reproductive loss events as a covered reason for a bereavement leave. And so if there's a failed adoption or miscarriage or something along those lines, that also counts under bereavement leave. And it is something where an employee does have the right to use their paid sick leave to cover that absence. But this is something that is a brand new covered reason. It is also, they can take multiple events per 12-month period with a max of 20 days per 12 months. And so it is important that, when you're updating your policy to include any limitations that you're going to include if you're going to follow the law and use that 20-day max to include that in your policy so employees know right out of the gate what to expect. And speaking of paid sick, I'm sure all of y'all have heard, it's not subtle, that we've had a pretty big change in California paid sick for the 2024 year. You probably recall California has had a paid sick leave law on the books for almost a decade, but not quite. And it was actually one of the lower amounts of paid sick leave for a state. It was at 24 hours or 3 days for many, many years at a state level, or you could accrue it at 1 per 30 with this rolling point in time cap at 48 and limit the number of hours taken per year at 24. So the new law is going to increase that annual allotment to 40. So if you're granting 40 a year under the state law, will work for you. If you are accruing, the same accrual rate applies, but the rolling max cap is now 80. And so it's a very significantly higher rolling cap than it was. And what's interesting about this is it impacts, whether this was on purpose or not, we'll never know. It impacts all of those local ordinances that had rolling caps at 72, because as you know, having a local ordinance doesn't get you out of the state law and vice versa. And so if you have a local ordinance subjected employee who has been accruing up to 72, that's got to raise to 80 as well. So it's something that we want to be paying attention to. There is going to be a requirement to provide either a new Wage Theft Act notice or some other notice that provides the same information so that employees can get notice of this change if you have to change your policy within 7 days of the change being made. So within 7 days of January 1st, 2024. And so keep in mind that not only is this a policy change, but it's going to require some things behind the scenes. And the last major ticket item in California that happened for 2024 is this new law around workplace violence plans. And it's only tangentially related to Handbook folks, because typically these types of plans are not in your handbook. This is very similar to an IIPP that would exist outside the handbook. We, as the handbook team, have been getting a lot of questions on it, and we've been partnering with our workplace safety team, our OSHA experts, on how to develop these, because they really are more of like an IIPP and separate, but they do need to include very specific things, and you have to comply by July of 2024. And so definitely reach out to us. We can partner with our workplace safety team on these, or you can make a reference to it in your handbook, in your workplace violence policy, and point to our new prevention plan that will help you as well. With that, I'm going to kick it over to Charlotte to talk about our Western states, the final frontier.
Thanks, Chelsea. I should have worn my pioneer hat. I'm going to be covering Colorado, Washington, Oregon, Utah, and Nevada in this section. The first for Colorado is not a new requirement so much as a reminder that public health emergency leave is no longer available for employees. It became unavailable on June 8th of this past year, after the president declared the end of the COVID-19 public health emergency. It's also possible that future public health emergencies, the declaration of them, will again trigger this obligation to provide PHE leave in Colorado. But for now, none is available. And then if employees had some that they didn't use, they forfeited that. In other ways, sick leave has expanded in Colorado, where employees can now take bereavement leave and during some inclement weather events. So there'll be new qualifying uses for the sick leave that will need to be listed under a sick leave policy. Benefits for the paid family and medical leave program will become available on January 1 of this coming year. So employers should expect an uptick in leaves of absences where they're receiving those benefits from the state. And if they don't have a policy, would want to consider adding a policy, or at least be ready to cite to how their policies interact with those. And then finally, for Colorado, this past year, the list of protected classes was expanded to include marital status, and the state eliminated the severe and pervasive standard for harassment. So joined the list of states, the growing list of states that is doing that. And now we'll move to Washington. Washington had two firsts for the state. Washington became the first state to really broadly limit searches of personal vehicles, which will be an exception to almost every employer's inspection policy. These are generally really written to be very employer friendly, give employers a lot of rights in the ability to find, stolen property or other things. This law outlines several narrow circumstances in which searches are allowed, including, police searches and the threat of immediate harm or death, but otherwise prohibits them. It's a policy that you'll definitely want to add as part of your updates for this year. And then secondly, Seattle, for those who have Seattle employees, Seattle expanded discrimination and harassment protections to individuals based on their caste or standing in social hierarchy. So calling out caste discrimination should be added to handbooks that cover Seattle employees, because it's such a new type of protection and there's not probably a lot of employee familiarity with it. And then we'll move on to Oregon. The state's paid medical and family leave benefits kicked in mid-year back in September. And so employers with Oregon employees are in the midst of that. And just in time for the start of those benefits, the legislature passed a bill fixing some of the inconsistencies between paid leave Oregon, which is how they've coined it, and the state's protected unpaid leave, OFLA, or the Oregon Family Leave Act, which are going to overlap 9 times out of 10. One fix was to unify the definition of family member across the board. And that definition actually trickles over into sick leave too. So if employees are just taking, 1 day of sick leave, they'll have expanded uses for taking care of family members. The more significant change was to adjust the calculation of the leave year. Now many, if not most employers, will be forced to change how they calculate the leave year for OFLA, the Oregon Family Leave Act, which is required to be identified in the handbook. And another impact of this change that's more nationally recognized is that employers may choose to expand That change, meaning the calculation of the leave year, to FEMLA leave that's taken by Oregon employees within the state. And lastly, we'll do a couple quick updates for Utah and Nevada. Over the summer, Utah repealed its guarantee of job protected leave for service members during active duty or other service. Nevada has now a speedier final pay requirement when people are temporarily furloughed. This may not feel applicable to everyone, but this type of requirement is something that became universally relevant during the COVID-19 pandemic when furloughs became nationwide. So if your employee handbook covers sections about the timing of final paychecks, which is not generally recommended, but it's a choice to be in there, it will be outdated if it's using Nevada's old standards. And then finally, Nevada also extended protected leave for employees that are victims of sexual assault or family members of those victims. Employees can take up to 2 weeks of unpaid leave, or what's unique about this law, request accommodations at work. So coming back to work with accommodations that would help protect them from further assault. So like a reassignment to a job, new location, or a change to a work phone number for being identified by the public. All right, now my turn is to pitch it back to Renata.
Thank you, Charlotte. So moving on to the Midwest, we'll go ahead and get started with Illinois. There's been a lot of movement in the leave of absence space this year. As you all are likely aware, there is a new paid time off law going into effect in January. And this law is similar to a paid sick leave law, but it requires employers to allow their employees to use this leave for any reason. There have also been some amendments to VESA, so employees can now use their VESA leave for bereavement-related purposes in the event that a covered family member is killed in a crime of violence. Illinois will extend the child bereavement leave beginning January 1st as well in the event of the death of a child by homicide or suicide, and the amount of leave available varies depending on the size of the employer. And then finally, there's a new organ donation leave law going into effect next year, and that is in addition to the blood donation leave law that was already in place. Moving on to Minnesota on the next slide, there's also been some movement in the paid leave space here. There's a new paid sick leave law going into effect in January, and notably with that, the state also repealed its existing KinCare leave law. The state has also enacted a paid family and medical leave law earlier this year, although the contributions and benefits will not begin until 2026 for that one, but we want to make sure that's on everyone's radar, even though we probably won't be putting those policies into place just yet. Minnesota also expanded its unpaid pregnancy and parenting leave law in July. So this law now applies to employers with only one employee in the state of Minnesota, and the employees are no longer required to work for at least a year or to work at least half time to be eligible for the leave. And finally, moving away from the leave space in Minnesota, there's also a new law restricting employers' rights to require employees to attend religious or political meetings that are sponsored by the employer. Next, we will take a look at Michigan very quickly. They amended the Elliott Larson Civil Rights Act. There are additional protections now for sexual orientation, gender identity, and gender expression as protected categories in Michigan. And on that note, I will flip it right back to Charlotte to bring us up to speed on the southern states.
Thanks, Renata. All right, we'll cover Arkansas, Louisiana, and Texas very quickly. Not legislatively heavy states in the employment sector. Arkansas passed their version of the Crown Act protecting natural and cultural hairstyles. If this is something that you include for other states, you want to add Arkansas as listed in that. Louisiana created a new category of leave for obtaining medically necessary genetic testing or preventative cancer screening. This is broader than you might think, and even would include appointments for genetic counseling, if that's even part of a regular pregnancy. It's a day of unpaid leave, and the employee will need to provide medical certification. But Louisiana doesn't mandate paid sick leave, so this would supplement any general PTO policy, and it should be added to the employee handbook as a separate category. And then finally, for this category, Texas also adopted protections for natural, protective, and cultural hairstyles. Texas also now requires large healthcare providers to develop workplace violence plans, similar to what Chelsea mentioned for California, but for only a subset of employees, and to implement protocols for responding to violent incidents at work. So that will be a larger policy development that will need to be taken kind of separate from the handbook. Pitching back to Renata.
Thank you, Charlotte. So, we've talked about all of these updates for this year, but I think it's also important to kind of go back to the basics and let's just take a look at, what is important about having an employee handbook? Why is it important to have an excellent policy, and why is it important to have all of these state addenda? So moving on to the next slide, we can start with just sort of the purpose of a handbook. And I think the purpose of a handbook is to establish uniform expectations. These are expectations for our employees. They're also expectations for our supervisors and managers. This is a document that our employees can generally rely on. Though it's not a contract, but this is something that's sort of a reliable guidepost, and this is how we are, sort of running our operations from a personnel perspective. It's important to communicate, policies from a legal compliance perspective. And it's also important to sort of have this guidepost that our supervisors can use just to make sure that we are being consistent, regardless of whether an employee is working for supervisor A or supervisor B, that, they are still subject to sort of those same general guidelines. So moving on to the next slide, we'll talk about why we need written policies. Well, there are a few reasons why we might need to have a written policy. The most obvious one, of course, being, when a policy is required to be in writing by law. And there are certainly many, many policies that we would recommend putting in our state-specific addenda, and certainly some of the ones that we've talked about today that, are required to be included in an employee handbook. There's also a lot of policies that, maybe they aren't technically legally required, but they're just simply a recommended best practice. It can also be helpful to include a policy if we are changing our practices on something, or, if there's something that's been kind of consistently going wrong or something that needs to be corrected within our organization. So moving to the next slide, what are some things that we need to think about before we start drafting a policy? Well, we want to think about, what is the purpose of this policy? What laws and regulations might be impacting this policy, and what do we need to be mindful of to make sure that we are legally compliant? And of course, there are a lot of different resources that we can pull from as we're considering those considerations. And then finally, we want to think about, is a template policy sort of like a one-size-fits-all? Does that work for our organization, or is there something unique to our organization that we would want to have, a very specific tone or something very specific in this document? And then finally, the last slide in this section will be, what should we tell our employees? So, what do we need to include in a good employment policy? Well, for starters, we want to consider who's eligible for this. An employee needs to be able to open up this document and say, does this apply to me? Am I eligible for this benefit? What are the rights that we're conferring to the employee? Are there any limitations on this? Sick leave can be a great example of this. So, many of the paid sick leave laws have waiting periods where they say you're not eligible to take this benefit until you've worked here for 30 days, 90 days, something like that. When does this go into effect? What are the reasons? If it's a leave, why can I take this leave? What do I have to do? Who do I need to talk to if I want to take advantage of this benefit? What are the specific notification requirements? And then what are the consequences to me as an employee if I don't adhere to the terms of this policy? You know, can I be subject to disciplinary action or that sort of thing? Also, you know, what are my resources if I don't understand this policy, or if I have any questions, or I feel like my rights have been violated? You know, who do I need to go to and talk to? It's certainly very important that we have someone identified internally who can respond to those kinds of questions and concerns, so that we can handle those, you know, with that individual before that becomes a situation that gets escalated. Examples can be helpful in some situations. I say this with caution, you know, to the extent that there's a complicated topic, it sometimes can help to sort of illustrate that for an employee so that they can sort of see in practice how this might play out and how this might work. On the flip side of that, you know, we can't cover every single possibility, you know, with every single policy that ever comes up. So we want to err on the side of, you know, not trying to be over-inclusive and making it very clear to everyone that these are just limited examples. And of course, we would consider individual circumstances. So with that, I will go ahead and flip it back to Chelsea, who will tell us more specifically about what CIFAR's Handbook and Policy team does.
Thank you very much. I did want to touch on one final thing that you mentioned on that last slide around examples, because one of the things that we are seeing, or that we are recommending that people look at for purposes of compliance with the new NLRB, hard to say, way of doing things, is including more examples and policies just to make it clear what it is we're actually trying to do and what we're not trying to do. And so whereas before, you know, pre-Stericycle world, I would have agreed that, you know, that use those sparingly, use with caution. I think it's a really great opportunity to be able to explain or expand on some of our policies that we've got that we think would be an area of concern under Stericycle, to add examples of some of the behaviors, for example, that we're trying to prohibit versus some of the ones that we're not. And so that type of clarity, I think, will continue to be really helpful as we see more cases under Stericycle. And so that I'm glad that you mentioned that last, because I think that's something that's very useful to keep in mind if we are trying to avoid the wrath of the NLRB under our new way of doing things. But I did want to spend just a few minutes talking about the handbook and policy team and what we're doing before we get to our sort of predictions and trends of what we're expecting to see for 2024 and beyond. And for those of y'all who have not worked with us and don't know the handbook team well, we do have attorneys from all over the country in every office who are working on handbooks pretty much around the clock, but especially this time of year. And every single one of those attorneys has been through a very specific handbook and policy drafting training. And we use our materials both internally as training that we do throughout our group, as well as an external resource for creating these projects and doing these projects for our client. And so what we have done behind the scenes is we've built a series of very easily updatable, customizable national templates and a state addendum for every state, even states that don't have a ton of their own laws. We do have materials for those states because sometimes clients want one everywhere, just in case you want that. Plus, of course, we have the District of Columbia as well. So that we've got these materials that are ready to be utilized and customized for an employer's needs. We've also updated our handy questionnaire that makes it incredibly efficient for employers and for us to be able to tailor around an employer's specific population, their industry, anything that might be very unique to that particular employer. The questionnaire helps us get to that without a lot of back and forth and a lot of time wasting. So it's a huge efficiency sake, and huge props to Jean Wilson on this call for taking the laboring oar in making sure that was in absolutely excellent shape. We also, in CIFAR, as many of y'all know, have a dedicated paid sick leave team that all of us are also members of, and a paid family leave team, same, that assists in kind of efficiently managing these national resources in these very particular and kind of hard to navigate spaces. And so amongst that partnership of our 3 teams, we're really able to tackle these multi-state projects because we know that there's almost no such thing as a single state employer anymore. They're very few and far between. When the pandemic occurred, we had what I have been characterizing as the Great Scatter, and everybody just moved everywhere. And so it really made it so a multi-state handbook became much more the norm. I think pre-pandemic, we were sort of dealing with a situation where maybe there was a headquarters and 1 or 2 locations. But now we've got employers who might have been in 5 states and are now in 30 or in 40 and get these questions all the time of the best way to navigate through those types of projects. And so these materials and these resources are really designed to be able to assist in that regard and make it really efficient. So on the next slide, we can talk just a little bit about what it is and what it's not, because I think that these things are very important and there's a lot of misconception around handbooks. I think unfortunately there does seem to be a lot of misunderstanding of the importance of a handbook, and I know Renata walked through some of the most important reasons why we want to have them. I know that when we were talking about Stericycle in our webinar last week, there was the kind of the question of why even have a handbook anymore, and honestly the best reason to have it is because it does help set those guidelines and set those expectations and make sure that our employees understand what their rights and what their responsibilities generally are as an employer of your organization, and gives you an opportunity to kind of show off a little bit. So it really isn't an option to just sort of grab something off the internet, slap your name on it, and distribute it to your employees. That would be very risky from a lot of perspectives. So what we've done is we've created what we consider a completely customizable tool. And so for clients who are looking for something brand new, we can build from that as a starting point, and we can base it on how many states or what states you need to figure out a price and an estimate of how much it will cost. And it really does slide on a scale of complexity, asking for a go back to the previous slide, if you will. Yeah, for clients that are looking for something, like in California, for example, that's going to be a lot more complex than an Alabama addendum. So there is a difference in how that's done. But most states really can be done for a couple $100 each. Or we can talk about ways to render them unnecessary by building in policies into the main book. Of course, if we have an organization that's looking for a review of an existing book and their state addenda, everything we've got already created serves as a really good behind the scenes resource for really efficient and cost-effective revisions. So we're very proud of what we've been able to do. I like to toot this team's horn because they've worked very, very hard. What it is not, though, it is not an off-the-shelf product that we give away or even can sell, because again, it requires that customization. It requires an eye towards who the organization is and what they're trying to accomplish, and a real understanding from the employer perspective of how these policies are going to impact their employees, and why it's so important to work collaboratively with the attorneys on getting this in place for you, because the last thing that we want to do is have you have a policy that you don't intend to have or that you didn't know was there. I get, unfortunately, questions like that all the time, and we want to avoid having that problem pop up. It's also not designed as one size fits all, because I think just based on what we've been talking about for the last 42 minutes, I think you can all understand why a one size fits all over everything isn't really practical. We do have very dramatic differences in the ways that laws are passed and managed throughout the country. And so if we're looking at, just from a wage and hour perspective, you likely don't want California wage and hour law to apply to your non-exempt employees working in Florida, because they don't have daily overtime, they don't have meal and rest break requirements in the same way. And so it isn't as simple as just saying, give me the most generous everywhere. I think a lot of organizations may not understand how expansive that is. And in fact, there are some laws that just don't mesh well with each other. And so even a very generous policy may not actually be sufficient to be technically compliant. And so we can work with y'all on that. And so obviously we recognize that because these materials have been created, it does make all of these projects take significantly less time and less customization than how it's been done in the past. So on the next slide, just talking a little bit about what it can do and how we can help. Our goal, of course, is to provide these very comprehensive handbook requirements and information for each state at the outset, so that y'all can stay on top of the new and changing laws across the nation. It really, these materials really increase the predictability of cost and timing of projects, and it will just really reduce the amount of time and fees spent on these projects, especially year over year. Because if we are starting with something that we've already created or we've already reviewed, then all we're really doing is adding the couple of things that changed, which is what we're in the process of doing for a lot of our clients right now, because this is the time of year when that is done. And of course, we will provide our contact information at the end of this session for those of y'all who need help, but we have a team of what I said, approximately 35 to 40 people throughout our organization who can and do work on handbooks all the time and can certainly be there and available for you. So with that, I will turn it over now back to Jean, who's going to talk about what we're going to be expecting to see throughout 2024 and 2025 as we peer into our crystal balls.
Thanks, Chelsea. So I'm just going to spend the next, 5 or 10 minutes just talking about, as Chelsea said, what we expect to see moving forward. And on the first slide, really just trying to look at maybe what is driving some of the trends that we're seeing. And one of the first things is, the change in administration, though maybe it's, they've been around for a few years now, but we've seen that the priorities and the policies of the current administration have really driven a lot of the changes that we talked about today. The focus on the National Labor Relations Board, the Pregnant Workers Fairness Act, the PUMP Act. Those are all things that were priorities of this administration and continue to be priorities. Now, again, that may change. We don't know what's going to happen with this next election. So one of the things we have found is that we're seeing more of a seesaw than I think we used to in terms of the administration affecting the laws that affect employees. The NLRB has really flip-flopped back and forth between, when there's Democrats there or Republicans on the board. So that'll be something we'll need to look at depending on who wins the next election. A lot of what we're also seeing are social and political issues that drive some of the policy work that we do. Union organizing is way up, and so really looking at solicitation and distribution policies, social media policies, recording policies, all of those things become much more relevant when you have union organizing going on. Still a lot of interest in the space around inequality and trying to, develop a society where there is more equity, and we see that play out in, discrimination and harassment policies, in diversity, equity, inclusion, and belonging. And then another area where we don't do a lot of policies, but we're seeing a lot of activity is in pay transparency. So those are laws that require employees to indicate on job postings or when they are doing internal postings, salaries, and sometimes benefits and other information about the job. And I think we're just going to see more and more of that. Massachusetts is currently, as just the Senate and the House have both just passed a bill in Massachusetts that looks like it is likely to be signed by the governor. They're still working out the language, but we're looking for that. And then, and I believe Chelsea mentioned this with the California bereavement leave, but we're also seeing a lot of activity in the reproductive rights space, and that affects policies in terms of giving people time off, bereavement leave, and also in some cases, employers are looking at giving travel stipends to individuals who may need to travel out of state to get that health care that they're looking for. We certainly are seeing a shift in the geographical location, as Chelsea mentioned. People have scattered, and that is really requiring a lot more state addenda work and a focus on what the wage and hour laws are in each state in terms of, meal breaks, final pay obligations, all the things that kind of go along with having employees in different places. And then the last trend is one that is really interesting, which is, technology and particularly artificial intelligence. And we are getting a lot of requests for policies around employee use of artificial intelligence. This is clearly right on the cusp, and we have a dedicated team at Cyfarth who does a lot of work in this space, and happy to help and talk through some of these issues. It's interesting and complicated. And so just kind of drilling down a little bit more on the next slide as to, how some of these trends really kind of play out. And really, I think the thing in the handbook space that is, what takes the most time and is the most challenging for employers is, trying to deal with having employees in so many different places. We are still seeing that people are scattered. We are seeing an increased hiring of fully remote workers. I talk to a lot of employers who are saying, we really need to do this to attract and keep the best talent. And so, that requires you to really look at your handbook and make sure that it is, nationally compliant often, and then you have the state-specific stuff that you're going to need. And obviously, it also implicates remote work and hybrid policies. We do recommend that you, really think through those. And then the next slide. And I'm not going to go through this one, but here are some of the things you want to think about with your hybrid and remote work policies. If you do some of this work up front, it can really save in the long run in terms of really setting expectations for employees so that they know what's expected of them, and you don't wind up running into problems because you don't have an appropriate reimbursement policy. Illinois and California both require that you provide reimbursement for work from home expenses in terms of internet and cell phone use. And so, you're going to want to make sure that you understand what states require that. And then, some of it, and a lot of what we do is also sort of philosophically talking to employers about what is it that you want to accomplish? Like, do you want to reimburse even if you don't have to in, every state? Is that something that you want to do? And if so, really, putting together cohesive policies that you can communicate to employees about the good things as employers that you are doing. And so the next slide is, so here is paid family and medical leave. I would say this and sick time are the two things that are the main stressors for employers in trying to be compliant, and the most difficult for us in drafting handbooks and addenda. It's probably where we spend, I would say, maybe 75% of our time often when we're doing a handbook. And I'm not going to go through this, but I did think it might be helpful if you just could see where there are currently paid family and medical leave laws, where we have 5 coming up in the next couple of years that are going to go into effect. And one of the things with these laws is they often apply to employers who only have 1 employee in the jurisdiction. So it's not that you need to have 50 employees or some, real number. It's often that it applies to 1. And so you really need to know it. The other thing is there are unpaid family and medical leave laws that you need to take into account because sometimes they differ from the requirements under the Family Medical Leave Act. We talk a lot about these paid family laws, but there are a bunch of unpaid ones that you'll also just want to make sure you're aware of. And at least in my estimation and in some of the folks I've talked to, the likelihood of us seeing federal legislation that would, we'd have a federal program. Certainly it is something the Biden administration would like to see happen, but it seems very unlikely that that would happen given the current makeup of the House and the Senate. So we don't really think we'll see federal legislation. And I had gone to a presentation about 6 months ago where one of the lobbyists who do a lot of work in this space said even if the federal government did pass this kind of legislation, she thought it was very, very unlikely that the federal legislation would preempt the state legislation, meaning that you now have this federal law that you have to comply with, but you still have to comply with all the state laws as well. So this is just an area that is likely to become more complicated.
Hey, Jean, can I chime in for just a half second?
Yes, absolutely.
Thank you. I did want to touch on one of the things about these paid family medical leave systems that we're seeing throughout the country is most of them do not include a written policy requirement per se, but because of the way they interplay with various unpaid medical leave benefits, especially in places like New York and California, where there are things an employer has to do versus things that the state has to do. For example, we do find it much more useful to include policies in this space, even if the language of the law doesn't say that we have to, because it's an area that causes a lot of questions for employees. And so this is, like Jean said, this is an area where we really do spend so much time in drafting to try to get this right or where an employer wants it. And that's especially true when an employer has employees in a variety of these states, because not tackling it at all really just leaves the door wide open for interpretation by the employee. And if we only kind of light touch it and from the perspective of one state, then there is a lot of implication that maybe, oh, I'm in a state that might not have that, even if there might be a law coming. So it is an area where we really do recommend, if you are in a state that has that kind of a program, to be paying attention so that you'll know, okay, this is an area where we're going to need to do a lot of partnership to make sure that our policies reflect what it is that we are doing, because in a lot of these, the law gives employers options of things either that they have to do and they can do it one of two ways, or things that they can choose to do. And so it's important to want to build that into your policy. Sorry, Jean.
Oh, no, perfect. And this is another one of those areas where an employer's philosophy can really matter in terms of what your programs look like. Some employers want to just provide what they're legally required to provide. Other employers are really focused on equity, in their different offices across the country or with their remote employees, and are trying to figure out, if the state plans require us to do this, is there something we can do on the company side so that everyone is getting generally the same level of benefit? So that is just one thing to keep in mind. And then the next slide just touches on, and we've talked about this a little bit, is discrimination and harassment. And so as you could see from some of the state changes, we are just seeing an expansion of protected classes that are being covered. Sexual orientation has been covered for a while, but we're really seeing it more explicitly covered, and also gender expression and gender identity. So a number of states have really made it clear that their anti-discrimination laws protect folks in those, have those characteristics. The Crown Acts we talked about, Charlotte talked about, and we, the two places that have that is Seattle and Fresno. Reproductive decision-making is an area that is now been made a protected status in some states, and New York City has just added height and weight in the last month to their protected categories. As I mentioned, and I believe Renata as well, some states are moving to eliminate the requirement that harassment has to be severe and pervasive to be unlawful. So really what you want to just do is keep an eye on your policies to assure they're in line with the expansion of these, and that you account for state-specific requirements. I know that, some employers wrestle with, do we want to put all of these protected statuses in our primary policy, or do we just want to have them in particular states? I would say from my experience, generally employers tend to be more inclusive in their main policy, so that they have to, because sometimes it feels uncomfortable to say, we're going to protect something in these states, but not in another. But again, that's another philosophical point that employers need to make a decision. And then the last thing that just wanted to touch on is diversity, equity, inclusion, and belonging. So this is a continued area of focus for a lot of organizations. The decision by the Supreme Court that many of you might be aware of regarding affirmative action in higher education has had some trickle effect. The concepts are a bit different, and that decision isn't entirely transferable to the employment space, but it is having an impact. And so it's another area that you really want to think hard about and get some guidance about. And the current social and political polarization obviously affects the space as well. So they can be really fraught in some companies, and we also have a group of folks who do a lot of this work here, and it's something else that we can help with. And then, you know, we do have employers often asking for policies around either banning or curtailing certain types of speech, political speech or speech about controversial topics. And, you know, this can be another area that's a little bit tough because of the NLRB. And that is going to wrap it up. I'm going to send it right back to Charlotte for the CLE code.
Thanks, Jean. All right, it is my esteemed honor to give you the CLE code. It's SS6794. SS6794.
Thank you so much, Charlotte, and thank all of y'all for joining us. I tried to answer some of the questions in the Q&A, and for those we didn't get to, we will circle back on all of those, but I do encourage you to brush off your handbooks, give us a call, give us an email if you want more information or you need some help getting it ready for 2024. It's going to be a big but great year. So have a wonderful day, and thanks so much for your time and your attention. And thanks, ladies, for joining me.
Thank you.